Few voices have shaped India's constitutional discourse, and the major one is Justice Indu Malhotra. A graduate of the prestigious Lady Shri Ram College, the Faculty of Delhi, the Faculty of Law, University of Delhi, she enrolled as an advocate in 1983 and became a senior advocate in 2007. In 2018, she made history as the first woman elevated directly from the bar to the Honorable Supreme Court of India. We are honored to welcome on stage Justice Indu Malhotra along with our legal editor, Rhythm Bharadwaj, in a conversation that talks about equality, women at the center of legalities.
Thank you, Justice Malhotra. It's an honor to finally have you here.
Thank you.
I've been requesting you to come to the Women's Summit for many years, and it's a pleasure for all of us.
Thank you.
You made history, ma'am, many years ago, 2018, when you were directly elevated to the bar. Your trajectory has been as a lawyer before your elevation to the bench. You were the first woman to be directly appointed from the bar as a judge of the Supreme Court. How was this transition from bar to the bench?
Well, the transition was smooth for the reason that I had practiced in the Supreme Court for over 35 years before I was elevated. So I knew exactly how the court functions because I had been a part of it. First as a junior lawyer, then I practiced as an advocate on record for almost 20 years, and then as a senior lawyer. So the transition was not hard at all. In fact, one former Chief Justice, whom I met just prior to my oath, so he mentored me. He said, "You've been in this court. You should not take long to adapt to the court at all." He said, "We find that judges who come from the High Court take almost 6 months to get adapted to the procedures and the jurisdiction because 136 is, very special and different from what the judges do in the high courts." So my transition was not difficult at all. And nor was I overwhelmed by the senior lawyers because they had been my colleagues at the bar.
And what has been your trajectory as a lawyer before your elevation to the bench, ma'am?
So I joined the bar in 1983. I worked with a solicitor's office for 3 years and then started my own practice. So after 4 years of practice, I took the advocate on record exam, and then I practiced as an advocate on record for a good 15-20 years. After that, I was designated as a senior lawyer in 2007.
Yes.
And 2018, I was elevated to the bench.
You were also there at a time when we've seen a lot of judgments were being passed. I want to ask you about the Sabarimala judgment, ma'am. You authored a very powerful dissent. It emphasized judicial restraint in matters of religious practices. How would you reconcile the view taken by the majority of gender discrimination against women from entering the temple between age of 15 to 50 years and the view that you took?
So it's like this. My dissent was based on the fact that it was really not a matter of gender discrimination, but it was the freedom to practice your religion and your beliefs as you want to, which is guaranteed by Article 25 and 26 of the Constitution. So 25 is subject to the other parts of Part 3. An individual has the freedom to practice and profess and propagate their religion. And Article 26 says that a religious denomination or any section thereof can maintain their affairs in the way they want to. That's broadly it. I have the Constitution in my hand. So I feel one point which was missed by the majority was they kept saying that the followers of this temple were not a religious denomination. But this protection has been given by the Constitution not only to a religious denomination or it's even any section thereof. So even a small section is entitled to, manage their affairs and, practice their beliefs as they consider appropriate. And where I differed also, The second point on which the majority said that what you are doing, in the sense of not preventing women from entering the temple between the age of 10 and 50 is not an essential practice. My response to that was that this is not for the courts to decide what is an essential practice of a religion or a section or a denomination or anyone. It's for that community to decide. And this issue was actually decided by a 7-judge bench. They said constitutional protection is given not only to your religion but also to your beliefs and practices. And that was done by a 7-judge bench. And later on, a 5-judge bench sought to, carve a kind of a slight exception by saying, but not what is superstitions, etc. And that's why it's been referred to a larger bench of 9 judges now, because, it's not for the courts. The judges are not theologians to decide what is an essential practice of a religion and what is not. It is outside the ken of the courts. It is for the community to decide, except if a practice is pernicious, for instance, sati, otherwise the courts ought not to interfere in the religious practices of any sect. A third point where I differed from the majority was that they said it's akin to untouchability. And I thought that was a very extreme position to take, because there's certainly no untouchability. It's just that women from that, sect do not go to the temple between the age of 10 and 50. It's not an absolute exclusion. It's a limited exclusion. They do enter the temple prior to the age of 10 and after the age of 50. And it's a self-imposed restraint. It's a custom being practiced since centuries. They say it's right from the inception of the temple. And this is because the deity in this temple has a manifestation of a Naishtik brahmachari.
Yes.
So that is why this practice has, is being followed for decades, centuries, in fact, not decades. And in the other temples of the same deity of Lord Ayappa, women do enter. There is no such embargo. So it's only associated with this temple. And I thought it was it's certainly not untouchability at all in any manner. So I disagreed with the view taken by them on these 3 or 4 grounds. And the most important thing which I do want to say, which was the threshold is very high. I feel PILs should never be entertained in matters of religion. You don't know who's behind the PIL. In this case, there were a group of lawyers who said that they were social activists and they were practicing in Punjab, and they read an article and they decided to file this writ petition in the Supreme Court. Now, it is a very slippery slope if you entertain a PIL in matters of religion. And I said, if you start doing that, it will happen in all other religions. And believe it, that by the time the review petition came, there is a petition which is challenging the non-entry of women into the dargah and the mosques. There's a second petition which has been filed with respect to, Parsi woman marrying a non-Parsi, not being permitted to go to the fire temple. And a third one is the Bohra community, which, they observe compulsory circumcision of young girls at the age of puberty. And this has also been challenged in the Supreme Court. So it's had a cascading effect, is what I had said in my judgment, and it has come true now. And that is one of the grounds which is mentioned in the referral order when it was referred to a larger bench. That was broadly my, thoughts and views on it.
Ma'am, just one thing about how was the experience at that time? Because I remember Mr. K. Parasaran was also appearing at that time, senior advocate, someone very revered. So what was that, and why has it gone to a 9-judge bench?
So it's gone to a 9-judge bench for the reason we were 5 judges.
Yes, ma'am.
Now, there are 2 judgments of the Supreme Court. So the first judgment was the Sirur judgment. It was by 7 judges. And they said it's not only religions, but even the beliefs associated with it. And all the traditions which are followed, they are also constitutionally protected by Article 26B. Then, after a few years, a five-judge bench came, which was headed by Justice Gajendra Gadkar, wherein he's in Venkata Ramana Daru, where he said that there may be some superstitious beliefs. So he, puts in that caveat as a note of caution, which goes contrary to the seven-judge bench. And that is the reason why it's gone directly to now 9 judges.
Right.
That was the ground which is
Right.
mentioned. And they said also now there are petitions which have come with respect to other religious communities, so it has to be finally decided.
Right, right. So that's the real reason. Ma'am, I of course the very famous Navtej Singh Johar case, the LGBTQ case where homosexuality was decriminalized. You were a part of that bench. In your farewell speech, you had even at that time mentioned that the pronouncement in this case was the most emotional moment for you in your judicial career. I also want to tell our viewers, I want to ask you why you made that comment, and I also want to tell our viewers there was this very famous paragraph, I think 644 of the judgment, where you said history owes an apology to this community. It's been spoken of, it's been written of, the community has celebrated these words. We spoke to several people in the community. We've also seen a lot of judgments internationally, a lot of legislations be changed after these words, this judgment. Why was it so emotional for you at that time, ma'am?
Not emotional for me personally,
Yes.
but I felt that, they had been wronged.
Yes.
In fact, the British Prime Minister had written to various countries which were earlier colonies. They said, we have, committed a human rights violation by incorporating it as a criminal offense in the Indian Penal Code and of other countries. So they said, please decriminalize it. And, the kind of persecution which they have suffered over the centuries, it's very painful. In fact, they didn't even get medical aid if they required to get it. So it was, and, the kind of celebration, it was a unanimous judgment. There were 4 judgments written, and there was, such a celebration. The court was packed with people from the LGBTQ community and their parents and families. And, they were jubilant when this judgment was passed. It also led to a change of perspective of the families of the LGBTQ, who had been alienating the family members, whom they found that they, were belonged to this community. They thought it was an abnormality, and they were, they really shunned them. A lot of them ran away from home, and there were a lot of very, very painful, stories written about in the press after the judgment was delivered. And there was huge celebration in the porch outside the chief's court. So it was a very emotional moment because
Yes.
you see that, there were actually people in tears.
Yes, I
You know that-
remember.
yeah. So that's
Yes.
why it was an emotional moment, and I felt that they had really suffered through the centuries because this is something which is innate. They are born with this orientation. It is not an abnormality, it is not an aberration, it is the way they are born, and you have to accept them for it. In fact, when I remember having spoken on the phone to a gay man, there were some interviews, and he was talking to me. He was suffering from AIDS. So we were asking him about, about medical assistance and all. He said, I lead a secluded life. Please don't call me again. But I do want to tell you that people are not aware of the percentage belonging to the gay community broadly speaking. And he said, all of you have an ostrich-like approach. And the High Court, when it said that it's a minuscule minority, shows how ignorant they were of the number of people who belong to this community. So they have gone through a lot of suffering. So that is what I felt that, it's so much of history gone by. And people, who come from the brightest, there were some who were from the IIT, they were from the army, and a lot of persecution they went through.
And ma'am, even when you were speaking, you were tearing up a little bit thinking about it. I remember I was in the High Court in 2008 when the Delhi High Court was hearing this.
Yes.
There was a big debate at that time. I remember when the Health Ministry and there was another ministry, they had different facts calling them abnormal before the Delhi High Court. It then came, of course, to Justice Singhvi's bench in the Supreme Court, after which it came to the bench when it was overturned. It's taken a really long time for this justice for them, but it's a celebration for all of us here. Ma'am, in the Rajneesh versus Neha case, it's a very celebrated, known case. Several people in the district courts, when I speak to them, speak about it. You laid down guidelines to harmonize the grant of maintenance under various statutory enactments, which helped women, which helped men. It also helped matrimonial cases and the solving of cases for people who wanted to go to the courts. Could you give us your views on this case and the guidelines?
Yeah, it's like this, that in this very case itself, the husband was just refusing to give maintenance to the wife, and repetitive adjournments were being sought. He was just making it as hard as possible. Now, I'm not talking from a feminist point of view, but I will give you a balanced point of view where I've appeared for both men and women
Yes.
in matrimonial matters.
Right.
So, in this matter, what I had found while I was in practice also, that frequently, lawyers would advise their clients, women clients, to, seek maintenance, because there are 4 enactments under which you could go. So, one was the Hindu Marriage Act. You could do it under Section 2425. Then came the Hindu Maintenance and Adoption Act a year later. File a second petition under that. Then came the Criminal Procedure Code, which was Section 125, and a third petition, and that was criminal. So, but the maximum amount you could get till the CRPC was amended was all of 500 rupees. And then the fourth one, was the DV Act, the Domestic Violence Act. So, if you file repetitive cases, it is also very difficult for the husband, because I found in some cases they would ask, say 5 lakhs in the first proceeding, second lakhs 10, third lakhs another enhanced amount. It was also by way of harassment. So I said, you need to synchronize it. You cannot take away the right of a party to, seek relief under any of these enactments or all of these enactments. But certainly, the party which has got relief in one is statutorily obliged to disclose it to the second court. And the second court will then set off or give an adjustment of the amount already awarded, and they'll take it into consideration if you're going on vacillating and asking for more and more enhanced amounts and file more and more proceedings. So the first issue which I wanted to deal with was overlapping jurisdiction, of proceedings filed in various courts and conflicting orders being passed. So this was the first one. Second is, I found that a lot of women found it very difficult financially to approach the courts, because litigation is expensive. And for that reason, and there is a lot of suppression which both men and women make in these proceedings. They don't disclose their assets and liabilities. So I drew out a chart and I said they will have to make this mandatory disclosure of what are their assets and liabilities, and there were various columns made for the urban and for the people coming from the agrarian areas, and Meghalaya is on a different level completely. So there were 3 charts made. So that was the second thing I did. And the third thing was that no repetitive adjournments will be given, not more than 2. If you keep asking for adjournments, then you lose the right of defense. It can be struck off. And one other point which I found, which was conflicting in a lot of judgments, was what is the date from which maintenance is to be awarded. So there were different, views taken by different high courts. So then I said it has to be from the date on which the application for maintenance is made. So these were some of the issues which got ironed out. And I said it's mandatory right at the outset to file the income tax returns for the last 3 years. Second is bank balances. And third is your assets and liabilities. And then I also laid down the criteria, the bench, which I was presiding on, that you must disclose, set the criteria. What should go, with the court when they are awarding maintenance. So, I laid down several criteria which have to be followed. So that was actually the conspectus of it, and it required a lot of hard work. This was one judgment which took me 3 months because I sent, questionnaires to the state legal services authorities, asked them to elicit views and give me their, thoughts on it. And I also did confer with leading lawyers who were doing family court matters, as well as some judges who had the family court matters in their roster. So, after getting all this information, it took me 3 months to draft this judgment, which I really thought was very important in matrimonial matters. So, and it's just not one-sided. Both parties, both the husband and wife, have to disclose their assets. There are a lot of cases where women are working, earning. They also don't disclose as much as men do. So both parties are obligated today by law to, file their affidavits of disclosure. So that was broadly it.
In fact, I spoke to family lawyers in Saket Court and they said we actually quote from the judgment. It's something that we use as a precedent because it really does happen sometimes if they have a person before them, every amount needs to be disclosed and it's not done. It's a field in which there is a lot of hiding. In matrimonial cases, and it's never open-ended. It's very open, so they said this is something we use. Justice Malhotra, as I'm talking to you, it's very clear that you're very direct, you're very clear, and your judgments are similar. You were one of the leading practitioners before you became a Supreme Court judge, ma'am. When it came to arbitration, your judgments that you've authored are looked at all across India, across the world. In your case, in your views, what reforms are required if it's possible, and is it possible to make India emerge as an arbitration hub?
So I think we have made major strides insofar as the conduct of arbitration proceedings are concerned. I think one of the most salutary amendments was the 2015 amendment, which has incorporated a statutory time period within which arbitrations have to be conducted. So it's actually streamlined the procedure, and we are, able to complete an arbitration with between 18 to 24 months, after taking maybe at least couple of extensions, because they are required as we go along. But, they are finished within a time-bound period. The clogging is happening actually at the section 34 stage
Yes.
and 37.
Yes.
Because there's so much of backlog, and, people find it very difficult to traverse through, the awards and the evidence, etc. What I feel requires to be done, in my view, is that there must be specialized benches. They must be trained. You are not to treat the 34 as an appeal. You are to look at the broad contours which have been, which have emanated from the judgments of the court, and also amendments done by the legislature, because the scope is narrow and you have to dispose them off.
Yes.
So they get clogged at the, at the 34 and 37 stage, and that is why that needs to be streamlined. That is where now the clogging is taking place.
I hope that happens, ma'am. I don't know if anyone is really going to pick it up and make it happen, but it's something that should happen so that we get a fantastic name as being an arbitration hub. Fingers crossed.
So, actually, the issue which I think concerns me at a personal level, where I feel it's very, very important, is particularly in international commercial arbitrations, because, the judicial delays had led to an investment treaty claim on India in the White Industries case, and they had an award was made. I think I don't remember the exact figure. I think it was some 14 million, and India had to pay just because of judicial delays. So we cannot afford that. It's very important that we have an expeditious system of dispute resolution. Otherwise, it will again become a precedent, and we can't afford it. For our own financial, for the country's financial development and growth, it's very important to have specialized benches and dispose of these matters as fast, because international commercial arbitrations which are seated outside the country come in for enforcement to India, and there are international commercial arbitrations seated in India. So, with respect to both of them, there must be a fast track rather than going in the ordinary way. We cannot afford delays.
Yes.
Because the main issue which keeps arising is how long will it take to dispose of a case in your country?
I thank you for being on the Republic Women's Summit, because this is a masterclass in constitutional balance. No matter what you say, I do believe, ma'am, it's not only your legacy, which has been in the judgments, but also the doors that you've opened for people, for the younger generation, and what they can do ahead. Thank you for being with us on the
Thank you.
Women's Summit.